Hello, I'm Richard Fairburn. I run HSC Professional, offering consultancy services to providers and managers of care homes and home care services. In this video, I'm looking at the requirements for notification under the Riddor regulations with particular reference to COVID-19. It may help if you've looked at my previous video on notifications under the registration regulations, where I looked at the definition of the relevant requirements, cue the reminder that we had recently from the Care Quality Commission. Notifications not to CQC, but these regulations are within the definition of the relevant requirements, hence their little reminder just as a marker of their interest. Unfortunately, this reminder doesn't cover the whole picture, which I will try to do now. Just to avoid confusion, COVID-19 was recently listed as a notifiable disease. This is for notification by general practitioners of cases of COVID-19, not to be confused with the requirement for notification of COVID-19 in the workplace by the registered person, which is not negated by that requirement on GPs. Now, if we look at the website of the HSE, we will find guidance to the regulations as relevant. So let's look at the regulations themselves. The Reporting of Injuries, Diseases and Dangerous Occurrences Regulations 2013. And looking at Regulation 9, Exposure to Biological Agents, where in relation to a person at work, the responsible person, that's going to be the employer, receives a diagnosis of any disease attributed to an occupational exposure to a biological agent, the responsible person must follow the reporting procedure. If it's worse than that, work-related fatalities, where any person dies as a result of occupational exposure to a biological agent, the responsible person must follow the reporting procedure. And the common feature here is a diagnosis. Now, diagnosis, and this is what the regulations say, means a registered medical practitioner's identification in writing where it pertains to an employee of new symptoms or symptoms which have significantly worsened. Obviously, if you have been notified that a diagnosis has been made, it's a fair assumption that that piece of paper does exist. Now, if we go back to the website of the HSE, they offer guidance as to the reporting requirement. So in the case of exposure, if there is reasonable evidence that someone diagnosed with COVID-19 was likely exposed because of their work, you must report this as an exposure to a biological agent. And in the case of the tragedy of fatalities, if a worker dies as a result of exposure to coronavirus from their work, and this is confirmed as the likely cause of death by a registered medical practitioner, then you must report this as a death due to exposure to a biological agent. And as I said, the common feature of these regulations is a medical diagnosis, and it's a diagnosis by a registered medical practitioner. There could be instances where it couldn't be anything else, and therefore one might report it as a suspected case, but note that the definition does not include other persons, such as an inspecting officer of the Care Quality Commission. Failure to comply with the requirement with the Riddor notification requirements would be a breach of the relevant requirements, potentially giving rise to a warning notice. What about the timing of reports in this situation? Well, in the case of exposure, a report must be received within 10 days of the incident, it says here. I've been unlucky and unfortunate in not being able to get any clarification of the Riddor regulations in this regard from the HSE, and when I referred the matter to CQC, they just said they hadn't drafted the regulations and they couldn't comment on any definition of the trigger for notification. So that's where the matter rests. In the case of fatal accidents or accidents resulting in specified injuries to workers only, The website indicates that this can be reported by telephone call. Now, what about the procedures for the care provider in this situation? As we did with the previous notifications, if we look at the defence in the case of a prosecution, it would be a defence to prove that the registered person was not aware of the circumstances which gave rise to that requirement, so long as that person had taken all reasonable steps to be made aware in sufficient time of such circumstances. And of course, this raises the difficulty of accessing the information that you need to make a notification where a member of the staff has gone off sick and you've had no further information. What this, if we transcribe this defence in a magistrate's court to your daily practice, what it indicates is a requirement to have a procedure to follow. And in the present circumstances, I would stick my neck out and suggest that under the present circumstances, when any member of staff goes off sick, the first question should be, could this be a notifiable incident? And a procedure needs to be in place in your service such that inquiry will be made. And I wouldn't pontificate on what calls should be made when, but that would be something to have within your own policies to demonstrate the reasonable steps to comply with this notification requirement. And that's it for this video. Please stay as safe as you can.